The case is Borjas versus Gamey. It's a premise liability case by a tenant versus a landlord for the landlord's failure to fix a broken exterior step outside the apartment unit of the tenant. The tenant had asked the landlord to fix it for about a year prior to the incident, and then one early morning the tenant forgot that the step was broken. He stepped through the void, fell down, injured his right knee. We arranged to meet him at his apartment unit. He was still immobilized. He had torn the patella tendon in his right knee. But as I got to know him, I learned that he lived for his family, and what was eating at him wasn't the pain to his knee. It wasn't about going through surgery. It was his inability to provide for his family, and that took away from who he was, his identity. No, it's not a knee case. It was Cesar Borjas, a story about how he had asked someone who had the legal responsibility, legal obligation to fix a dangerous condition, and who didn't fix something that was obviously dangerous, and because of that, a man in his life was injured and been damaged. Along with any premise case, is the defense favorite argument is comparative fault. The plaintiff should have been looking where he was going. Had he been looking down to the ground, he would have seen there was water, he would have seen the broken steps. One of the danger points in his case was the fact that he knew that step was broken. He had asked the landlord to fix it. He had asked the landlord to fix it over a year ago. He forgot about it, he stepped through it, and then he fell. Mr. Borjas' work was a truck driver. He was a teamster, so he lost some money for that first 10 months. And then following the first surgery, he kept following up with his doctor, and his doctor kept saying, you're fine, you have some residual pain, that's just normal. But then following the first mediation, Mr. Borjas kept complaining about his knee pain. So I said, well, let's get a second opinion because something is not right. It's now almost 1 year post-surgery, he's still having some significant pain. So we had him evaluated by another doctor who said no, he has what's called a patella alta condition. The kneecap is now a little too high. So based upon that information, we went back to the defense counsel saying, well, we can no longer negotiate where we were. The defense maintained that it went from 200 to 300 to 400 to 600 to 800, while at the same time we just maintaining and saying we want the policy. Ultimately, they made their final best offer at $975,000. I communicated that offer to the client. He ultimately accepted that offer. It's important to recreate what happened. And so that's when I made a decision early on in Mr. Borjas' case to reach out to MotionLit to get an animation commission so that we could use that as part of our tools in examination of witnesses, and ultimately use it during settlement negotiations, so to let the other side know that we are serious about presenting this case to a jury if they don't come up with a fair and reasonable amount for Mr. Borjas to compensate him for what happened to him. The animation had to show that given the size of his shoe, the width of the void, that Mr. Borjas can literally step through the void without making contact. So the animation was fantastic because we had MotionLit recreate Mr. Borjas descending the staircase. Lighting was an issue because this had occurred at 5 o'clock in the morning where the lighting was dark. There was also an issue with a light fixture that was missing down below where the last step was. And working with the safety expert, MotionLit was able to recreate the animation that depicted the correct lighting, the motion for Mr. Borjas, and then the second aspect is then the mechanism of injury. The force from the fall causes the kneecap to move forward and up, and that stretched the patella tendon to the point where it snapped. And so animation is critical if you can get it early on because it helps prepare witnesses. It helps prepare your clients when you're preparing for deposition. If the other side knows that you're willing to spend the money on animation, the time, that you're taking the case seriously. And nothing scares the other side more when you tell them you're ready for trial. This is where I love using MotionLit. You guys are very responsive. When I have a question, I send an email, you guys respond immediately. Likewise, you're great working with my experts because my experts are busy and sometimes they only have a very small window to do things, and so having that access is critical. The work product is the proof itself. The animation, the service, the value that you get, it's all there. If you're a lawyer who needs an animation, then give MotionLit an opportunity.